Senator judges impartiality, decorum, and the internal remedy. The chair begins where institutional discipline must always begin, with the court itself. The restraint, impartiality, and decorum demanded of the parties and their counsel must first be exemplified by those who sit in judgment. As senator judges, let us keep in mind our oath, quote, to do impartial justice according to the Constitution and the laws of the Philippines, close quotations. And the requirement under Rule 3 of the Rules of Impeachment to observe political neutrality therein defined as, quote, the exercise of a public's official duty without unfair discrimination and regardless of party affiliation or preference. The chair likewise cites the relevant provisions of the 2025 Code of Judicial Conduct and Accountability, or CIPRA, on impartiality and the sub judice rule. Canon 3, Section 10 provides, quote, during the pendency of a case, a judge shall not knowingly make any comment in and out of court that could reasonably be expected or perceived to affect its outcome, impair the fairness of the process, or diminish the public's confidence in the court's impartiality. Canon 4, Section 24 provides, quote, a judge shall not engage or use any form of expression which tends to violate or has the effect of violating the sub judice principle, provoke or inflame divisive and contentious issues of public concern, or project an image not compatible with the dignity of their position. Taken as a whole, these principles remind us of our duty to preserve the impartiality of this court and the fairness of these proceedings. As the court said in People v. Court of Appeals, GR number 118882, this court has repeatedly and consistently demanded, quote, the cold neutrality of an impartial judge as the indispensable imperative of due process. Judicial proceedings are not orchestrated plays in which the parties are supposed to make motions and reach the denouncement according to a prepared script. There is no writer to foreordain the ending. Close quotation. Also in Berso versus Rabe, AM number RT 21010, a judge must not only be impartial, but must also appear to be impartial, as an added assurance to the parties that his decision will be just. Litigants are entitled to no less than that. For avoidance of doubt, this shall not prevent senator judges from examining the evidence where the examination belongs during the proceedings and on the record. The Supreme Court in People v. Gambor, GR 152183, said, the trial judge is accorded a reasonable leeway in putting such questions to witnesses as may be essential to elicit relevant facts, to make the record speak the truth. A judge may examine or cross-examine a witness. He may propound questions to test the credibility of the witness and to extract the truth. He may seek to draw out relevant and material testimony, though that testimony may tend to support or rebut the position taken by one or the other party. It cannot be taken against him if the clarificatory questions he propounds happen to reveal certain truths which tend to destroy the theory of one party. Taken together, Rule 17 and the Gambor case confirm that a searching question is not partial merely because the answer may aid one side or weaken the other. The prosecution and the respondent's counsel must be prepared to answer such questions. The inquiry must remain relevant, material, fair, and directed toward clarification of truth. It must not devolve into a speech, harassment, partisan advocacy, or an announcement of a conclusion already reached. The line is clear. Senator judges may test the evidence here under oath and on the record, exercising the cold neutrality of an impartial judge. When constituted as an impeachment court, the Senate does not cast aside the discipline of parliamentary practice, except where the specific rules on impeachment or the adjudicative nature of these proceedings require otherwise. The rules of the Senate establish parliamentary precedents and courtesies of the chamber continue to bind every member sitting as senator judge under Rule 34, Sections 93 and 94 of the Rules of the Senate. Deem acts or language that offend a senator or any public institution or third party to be unparliamentary and prohibit the use of offensive and improper language against another senator or public institution or third party. Henceforth, I hope senator judges shall refrain from unparliamentary remarks, personal attacks, imputations of improper motive, and other language incompatible with the dignity of these proceedings and of parliamentary courtesy to other people. The chair will at all times extend to his fellow senator judges the courtesy befitting equals and reasonable latitude that serious deliberation requires. Differences in judgments and vigor in debate are to be expected and shall, as far as practicable, be met with patience, flexibility, and respect. Should circumstance so require, however, the chair will not hesitate to enforce the rules of this impeachment court, the rules of the Senate, particularly sections 95 and 96. In this chamber, firmness need not be unkind, nor courtesy come at the expense of duty. Both serve the same end, the fair and honorable administration of justice. Further, where a senator judge is alleged to have violated the impeachment oath, Rule 3, Rule 18, or any other applicable rule of the Senate, an available institutional remedy within the Senate is the filing or referral of an ethics complaint to the Senate Committee on Ethics and Privileges in accordance with the internal rules of the Senate. Under Rule 10, Section 1316 of the Rules of the Senate, the Committee on Ethics has jurisdiction over all matters relating to the conduct, rights, privileges, safety, dignity, integrity, and reputation of the Senate and its members. Any disciplinary action remains for the Senate to determine under Article 6, Section 16.3 of the Constitution and applicable rules. This shall not be a proper subject matter to be taken up within this impeachment court so as not to divert the attention from the impeachment trial against the respondent in this case. Accordingly, the chair reminds all senator judges, first, to observe the impartiality and political neutrality required by their oath and the rules. Second, to observe the parliamentary rules, precedents, and courtesies of the Senate and refrain from unparliamentary, offensive, or improper remarks. Third, to exercise their authority under Rule 17 to question witnesses, prosecutors, and counsels for the respondent and the prosecutor during the proceedings on the record instead of through commentaries in social media.